Okay,
Standing room over here.
That's right.
we're ready.
All right. Thank you so much, Angela. Good morning, everybody. Welcome to Bar Talk on this April 12th of 2021. Nice to virtually see all of you. I'm Kelly McDonald, the president of the Maine State Bar Association. Excited to kick off this week with a fun episode of Bar Talk. I hope all of you had a good weekend. I had the pleasure of taking two of my kids and my dog paddling down the St. George River up in Searsmont, which is a great river, part of the spring rotation of whitewater canoe races. But of course, many of those races aren't happening. So we just went out and enjoyed the paddle. I hope all of you had a good weekend as well. We're delighted to welcome Derry Rundlett as our guest here today on Bar Talk. And as you know, we have over the past couple of months been trying to provide a single practice tip with each of our Bar Talks. And so when we reached out to Derry to see if he had a single practice tip, he essentially told us, I can't limit myself to just one or to just a few minutes. And so we decided that it might be interesting to dedicate an entire guest speaker episode of Bar Talk to hearing from Derry. Derry has a great deal of experience, primarily in personal injury law. He wrote a book called Maximizing Damages in Small Personal Injury Cases. And he just told me before all of you came on that a couple of years ago that passed 2 million volumes being printed, which is pretty cool, very impressive. And so, Derry, you've got some ideas and tips and strategies that you have accumulated over, what is it, 1 or 2 years of practice? And so, how many?
47.
47. All right. Well, not too bad. And so we really appreciate you coming on board with us today and sharing your thoughts with us. We are going to invite everybody. Feel free to offer up your questions of Derry. I'm going to save all of those till the very end, and we'll ask them then. But go ahead and stick them in chat as you think of them. It won't interrupt the flow of things, and it'll give us a list to hit at the end. So again, Derry, thank you for being here.
Thank you very much, Kelly, for that introduction. And by the way, the number of copies is not 2 million. It was $2 million in sales because I also sell supplements. I just wrote my 26th supplement for the book. This is what it looks like. It's pretty thick. A lot of forms are online. And what I'm about to speak to you folks on today is a section that I wrote when I first wrote the book, called 14 Negotiating Tips That Really Work. And I thought it was pretty good when I wrote it, but the American Association of Justice, at that time, the American Trial Lawyers Association, thought they were good enough to put in their magazine, Trial Magazine, read by over 100,000 or 200,000 personal injury lawyers. I was very proud of that. And my company thought they were good enough to put in their brochures that they were sending out for other books. So they send an advertisement for a book and say, by the way, these tips from Rundlett are free. And the third example is a lawyer out in the Midwest put these tips word for word on his website as though he wrote them. And I'll tell you what happened with that at the end of this story, at the end of this presentation. I'm sure you're waiting with bated breath. By the way, the ultimate summary of negotiation, in my opinion, came right out of the movie The Godfather, when Michael Corleone says, we're going to make an offer he can't refuse. And I have used that phrase many times in negotiation when I've said, make an offer I can't refuse, or when I'm making the offer, I say, I'm going to make you an offer you can't refuse. I don't mean violence, I just mean a decent number. And many times in judicial settlement conferences, I've said to the judge, I'm about to make an offer they can't refuse. And the judge has said, gee, I agree. So let us start off with number one. And that is, have a confident attitude before you begin negotiation. Well, you might say, yeah, my God, that is so elementary. But it's amazing that when you negotiate from a bad point of view, feeling good about yourself, maybe your practice is not doing so well, never negotiate when you're hungry. I run senior track, I run the sprints. And when I show up at the track, I'm just so happy just to be able to run against other old guys that the confidence is already there. So have that confident attitude when you go into the negotiation session. And the other 14 tips that I'm going to give you, I'm actually giving you 15 today, they'll help you do that. Number two, know the law. Folks, again, what is this very elementary thing you're saying? Well, amazingly enough, I can't tell you how many people go to mediation sessions or negotiation sessions and they wing the law. I'm doing a seminar, a webinar in 2 days called Mediation Tips. People are going to spend $100 to listen to me speak. But I'm going to talk about the fact that mediators often tell me that lawyers come in and they don't know the law. You need to know the statutes, the case law. You need to know what the law affects your particular situation, whether it be a divorce, a transactional situation, or a personal injury case. You need to know what the law is on comparative negligence, what it is on the statute governing running a red light or being negligent. So it may sound elementary to you, but know the law, know the statutory references, know the case references, and make mention of them once in a while so the other side knows that you know the law. My partner, Bill Childs, always prepares the law. Harry Glassman used to tell us, read the statute. Okay, moving on to number 3. This says prepare, prepare, prepare. Ralph Lancaster, truly one of the greatest trial lawyers in our history, perhaps the greatest, once spoke to us and said, you know something, I'm probably going to win my case against you, not because I'm smarter, not because my case is that much better, but because I'm going to prepare more than you will. And I learned that. And I learned that when you went to trial, when you went to court, when you went to mediation sessions and you prepared, the judge would like you for doing that. It's especially good if he likes the case or she likes the case. So if the judge likes you and likes your case, that's good. And they're going to like you if you are prepared when you come in the courtroom. So never negotiate without having a complete knowledge of your file, its contents. So if they say, gee, I think you didn't send us that report. Yes, I did. Here it is, April 16th, 2015. I sent you that report. Okay, number 4, negotiate from an agenda. Not an agenda that you give to the other people. It's your agenda. And it's just a few notes about what you want to cover. If it's personal injury, you're going to want to discuss liability. You're going to want to discuss damages, discuss pain and suffering. You're going to discuss potential jury appeal. If it's a divorce, you're going to discuss child support, alimony, the visitation, whatever. You have your own agenda of what you want to cover in that negotiation session. You don't need to shove it down the throats of the others. It's just what you want to cover, what you want to accomplish in that session. Number 5, learn how to listen as well as talk. Folks, I'm a talker, so I like to talk a lot, but it took me a while to learn this particular tip. But I'm going to tell you, not only does it show that you are polite, you will also get nuggets. You will get bronze, silver, and gold nuggets from what they have to say. So you listen carefully. Let me give you an example. I was in a mediation session in Bangor. The case was our guys driving down a logging road. And those logging roads, folks, they're very dangerous. And you're supposed to have a CB radio and find out where the other trucks are. Well, he had a new truck, no CB radio. He got struck almost head on by a very fast moving logging truck. Took away half his truck and broke his arm. He could have been killed. We filed suit in Aroostook County, where both people were from. We got to the mediation session in Bangor, and I gave my opening statement about liability and damages and so on and so forth. And the mediator asked, the defense counsel can speak, but before he did that, the owner of the trucking company, who was sitting there, and the driver was a very nice man, but the owner was very angry. And he said, I want to speak. And he went into a rant about me, about my case, about my client. You lawyers from Portland come up and tell us about how we're supposed to live up here. And then he says, I'll tell you something, buddy. He said, there's not a jury in Aroostook County that's going to give you a dime in this case because we all stick together. He finished his statement. And I'll tell you, my client thought I was going to rip him a new one. The mediator thought I was going to get mad. I didn't. I said, sir, thank you very much. That was very well said. Whoa. Mediator said, sir, you can leave the session now. Thank you very much. Go get some donuts and coffee from outside. When he left the room, I turned to the mediator and said, well, if this case does not resolve, I'm going to file a motion for change of venue and I'm going to ask for jury voir dire conducted by the attorney. Everybody chuckled, but the mediator, who had been a judge, said, Derry, your motion for change of venue will be granted, but I'm only going to give you Penobscot County or Piscataqua. I'm not going to give you Cumberland County. And the defense attorney laughed, but knew that I had enough ammunition for a motion for change of venue because I sat and listened to that guy. And his comments would have been Exhibit A. Okay, moving on to number 6, do not interrupt. It's very, especially in a negotiation session when you're doing one-on-one. There's no mediator, there's no judge there. Do not interrupt. You want to interrupt, but instead write down the notes, listen to them, and let them finish before you interrupt. Nobody likes interruption. It's not just polite, but again, you might get some nuggets. Number 7, never express anger, frustration, fear, or sorrow. And I changed that today. I wrote that when I was a younger lawyer. Now I write seldom express. Once in a while, you're going to lose it. You're going to express your own emotions, and that's okay. But I will tell you that when you express anger, when you express sorrow, when you whine, it doesn't come across well. I also tell my clients, do not react. Do not react to the offer. They're going to come in with a low ball. You don't say a word. And by the way, mediators don't ask the client, well, what do you think? They don't do that. And I have to tell you that when I talk to the mediators to prepare for my session on Thursday, I'm doing a session national webinar. When I talk to the mediators, to a mediator, they said, Derry, we hate whiners. People that come in and the minute they start, oh, the insurance company's horrible, or that my husband's lawyer is a dipstick, and it doesn't work, folks. It doesn't work. Okay, moving on. Use questions as well as answers. When you're negotiating, it's appropriate to ask questions. For example, my client's medical bill is unreasonable. Are we way out of line on our child support request? Do you think my client should receive no compensation for pain and suffering because your offer is basically special damages? Well, what's the difference? Are we just having a problem with difference in value, or do you have a real defense to this case? One of the most important questions I used to ask a defense counsel was, I would say, defense counsel, if you were in my shoes, what would you do? And very often they would tell me, well, Derry, if I could get a settlement between 40 and 60, I would think that was pretty good. And the defense attorney would be telling me just where they might be going. So you can ask questions as well as giving answers. Number 9, never bluff a lawsuit. Nobody's afraid of lawsuits today anyway, after this COVID thing. And I never used to bluff lawsuits unless I was prepared to file it within a week. Also, back in the old days, you could write a lawyer's letter to somebody, and nobody cares about that. Nobody cares. So don't bluff a lawsuit unless you are prepared to actually bring that suit. Okay, that's an easy one. This one also very easy, just a minute or two on it. Always return phone calls and answer letters promptly during the negotiation process. If an adjuster contacts me and we're in the middle of negotiations, I don't wait a week. I get back that day. If I get a letter, I respond within a couple of days. That's just very elementary, but it's very important that you just keep the process going. You keep the river flowing. Number 11, never threaten to jump the ladder. Especially in insurance cases, you're not doing so well with the claims adjuster, and you threaten to go to the supervisor or the manager. The companies don't like it. Or you're talking to an insurance adjuster and you say, I'm going to call your defense attorney. I know who your defense attorney is. I'm going to call her right now and complain about you. That does not work. And I stopped doing that a long time ago. Number 12, it says don't play lawyer. Well, if there are other lawyers, that's fine. But if you're negotiating with a person who's not a lawyer, maybe it's a transactional business, maybe it's a divorce case, whatever. Maybe you're talking to the insurance adjuster directly. Do not start playing lawyers, starting how many cases you won, whatever. They're not impressed. They got defense lawyers that have tried far more cases than you have. So playing lawyers does not really work that well. Number 13, do not be afraid to walk away from the table. Well, when is that supposed to occur? Well, it's when they made an offer, you can refuse. Or it's when the mediator or the judge has said, Tom, Kelly, you're not going to get any farther on this. You might as well walk away. By the way, one day a mediator told me to walk away. And the next day, the defense attorney called me and said, Derry, why did you walk away? I said, because the mediator said I should. She said, well, actually, I got more money. And so maybe his advice was good. Maybe he knew that if I walked away, I might get a call the next day. And we settled the case of that phone call. So there are times when you should walk away, but believe me, never early in the session, unless the mediator says, Derry, don't bother to stick around. They're not going to go any higher. You might as well walk away. Okay, number 14. Some people disagree with me on this, but this has worked very well. Accept a reasonable offer, even if you think you can squeeze more. Folks, I just told Angela that a week ago I was in a bad auto accident. My car was totaled. A guy ran a red light. He lied to the police, but they found a witness. They cited him for red light. They cited him for no insurance. I'm okay, thank you. But the appraiser made an offer on my car this week. It's 13 years old. It was 50 when I bought it, but it's only worth about between 6 and 8. He made an offer of 6. I went on the internet. I found a whole bunch of comparables. And I called him back. I said, listen, 6 was about the lowest I found. I found some 9s. I found some 10s, but I found a lot of 8s. He says, what do you want? I said, 7,000. He called me the next day. He said, Mr. Rundlett, we have 7,200 for you. So people might say, well, you should have asked him for the 8. You should. No, 7 was fine. So always accept a reasonable offer for another reason. I had 2 cases where they made a reasonable offer. In fact, an A offer. And I tried to squeeze more. In those 2 cases, one of them withdrew the offer. I had to beg to get it back. And the other one, the attorney said, the justice said, well, Mr. Rundlett, I'm pretty sure that you know that the offer I've given you is like the best you could possibly get. I'm pretty sure you know that. So I'm just gonna renew that offer. And I accepted it. Well, folks, I've almost run out of time, but I want to give you number 15. Because number 15, I consider to be the Hail Mary pass. And this has worked for me. And I would like some of you, if you use this tactic frequently, to let me know. Derry@portlandlegal.net, because I think this is my best tip. And that tip is this: always be prepared to reduce attorney's fees. If you're in mediation, let's say you got an offer of 50,000, and you really wanted to get over 50. You wanted to get closer to 60. That would have been a home run. They say to the mediator, well, 50, that's pretty much it for us. I say, can I please meet with them, or can you tell them that if they go to 55, I will not charge a penny from that extra 5,000, not a dime. I can't tell you folks how many times that has worked, whether I did it in person or whether the mediator did it. I always knew that the mediator said, I'll ask him, that he knew that they would do it. If he thought they might or might not, he'd say, well, Derry, go ahead and try that. So guess what happens when they come back and say yes? That settlement just went from 50 to 57.5 in the terms of the client. If they go to 4, it just went to 56. If they go to 3, it just went to 55. And you might say, well, Mr. Rundlett, what do you do if they don't do a dime? I reduce my fees. I told my client, listen, I wanted us to be north of 50, so I'm taking $1,000 off my fees so that we can at least get above 50. I got to tell you something, folks. That works not only in non-catastrophic cases. Terry Gami and I just used that very tactic in a case that settled for 1.2, but the value to the clients was 1.4 because we reduced our fees. And when we told the lien holders that we reduced our fees, they went, whoa, then we'll reduce our lien even more. And they made that settlement the equivalent of 1.4. So folks, I got to tell you, these negotiation tips will work unless you're in a case where the emotions are so high. It's a divorce. They hate each other. They just want to fight. Rowland versus Kingman, the most hotly contested divorce case in Maine history. If they just want to fight, it's probate litigation. The siblings hate each other. None of these tips are going to work. So that's it. Thank you very much for listening. I look forward to speaking to you again. And Kelly, if we have some questions, I'll be glad to answer them.
Oh my goodness, Derry, that was just fantastic. What fun to hear you share those stories and those ideas. And I have to tell you, I have never to this day taken notes during a bar talk session. but I did this time.
Oh, well, thank you.
I wrote down all 15 tips. They'll come in very handy. And Derry, I don't know if you were on the Bar Talk a month or two ago, but longtime listeners will be familiar with this. We had an attorney on the show who shared a practice tip that he and I experienced during a mediation where we were on opposite sides. It was a situation where the two parties were at an impasse, just a couple $1,000s apart, but they had both drawn their line in the sand. One of them proposed flipping a coin and the other one loved it. And all the lawyers were aghast. The parties were delighted, and we flipped a coin and one side won and one side lost, and they were delighted. It was great. So I'll offer that as number 16.
Number 16, I also, I used to, when I speak in person, I also say beg. By the way, I forgot to tell the audience, the guy that put my tips on the website, my publisher contacted him and said, would you please remove him? He wouldn't do it. He wrote another letter, he wouldn't do it. And so my publisher made an offer he couldn't refuse. He called him on the phone and said, if they're not off there by tomorrow, I'm contacting your Board of Overseers because you just violated the following rules in Kansas. 421.2. So that's how we took care of that. Kelly, thank you so much.
Excellent. All right. So here are some questions. First of all, the guy who hit you, Derry, is he now on suicide watch once he found out who he had hit?
I will tell you this, folks. I'm friends with a singer by the name of Bobby Rydell. He sang Volare. And the movie Grease, Rydell High School is named after him, and he and I are quite close. By the way, 60 years ago, Volare was number 2. He wrote me a text and said, Derry, now that you're okay, I'm going to send some people up from South Philly to get that guy. So, yeah, I was very upset that he did that. If he'd come over to the car and apologize, it'd be a different story. But thank goodness they found a witness. And so thank you for that. That's a nice question, by the way.
And then someone asked if there's going to be a way for folks, apparently if somebody was not taking notes, and I'm happy to share my notes if you can read my handwriting. Someone's curious to know whether there's a place they can find these tips written down. I bet the answer is in that book that you're holding right there.
Definitely in the book, but also I think James Publishing, if you Google them up, I'll Google up James Publishing, Derry Rundlett 14 negotiation tips. I'm pretty sure they'll pop up because that's where the other guy, Wes, got them. And you're welcome to use them, but just make sure I put my name in.
That sounds like good. That sounds like good legal advice right there. All right. Any other questions for Derry? Not a negotiation tip, but tell about attaching the QE2 launch.
The QE2 launch.
That doesn't. All right.
I was on the Queen Elizabeth II and the Queen Mary II. So I don't know if that's the reference or not.
I might be misunderstanding. We'll come back to that one. I've got several comments coming up. That was great. Thank you. Great to see you. Derry, again, that was just really great fun. So thank you so much for being here and sharing all that with us.
I have to say to everyone that it's a great honor to do this and to be appreciated. Thank you so much.
All right, and of course, Derry, feel free to stick around as we go through slightly less exciting things. Just a couple of updates from around the state. As you may have read in the news, there's a mobile vaccination unit that's getting fired up to help out our fellow Mainers who are homebound. I hope folks are getting in line for their vaccinations, and that over the next month or two, we'll get those numbers up as high as possible. Angela, over to you for MSBA updates.
Good morning, everyone. Thanks, Derry. Just a reminder that we have sent our request for proposals out for the Summer Bar Conference, which will be held virtually on June 24 and 25. I think I have those dates right now. Also, this is the last week to get in nominations for the Blue Award. Please send those to me by email directly. And finally, just a reminder, there will be no bar talk next week. It is Patriots Day and school vacation week. And so we know a lot of folks are going to be out of the office.
All right, excellent. So I'll tell you that I just quickly Googled James Publishing, Derry Rundlett. Derry, I got 16 points of negotiating a small personal injury claim. And it looks like they are different tips. So perhaps we need to Google mediation tips or something like that. So there's lots of tips out there, an additional 16. Offering up the wellness tip. And this is something I'm trying to tell myself and my children, which is walk away from set the screen down and walk away slowly. We spend all of our time looking at these screens burning into our retinas, and it's good to get outside.
Kelly, maybe not slowly, walk away quickly.
Walk away quickly, run, run. The gratitude that we've offered up for the day is going to be different depending on where you are, because I know that there are spring flowers coming out down here in Portland. Up north, I think people are pretty excited about the ice going out. And then I think that's all. Angela, have I missed anything?
No, sir.
The only thing I have left to tell you is have a wonderful week. And we won't see you next week because we're going to take the week off, but we will see you the following week. So thank you all for being here for Bar Talk. Derry, thank you again. Everybody take care.
Thank you, Kelly.